Yes. Welcome to the continuation of our series on the admissibility of different types of evidence in South African courts. We are looking at the admissibility of hearsay evidence, opinion evidence, similar facts evidence, previous consistent statements, character evidence, admissions, and confessions. In our other videos, we look at all the other ones, but this particular one is dedicated to hearsay evidence. So sit back, relax, look for the other ones, by the way. They are available, so you can have a complete picture of everything that is being discussed. It is sufficient for me just to say, just to remind you to like the video, to share it with your friends, to subscribe to the video, to hit the notification button, and to continue to grow the community, to participate in all our other activities. For instance, we've got our chat groups, we've got our email account. So whenever we release a video, we'd like you to be the first to receive it. We've got other videos that are accessible only to a select few, that is those who are registered, to access them. So make sure that you register. Now, so much about that. Let's move to the business of the day. I have suggested here a reading list. Some of the articles that you may want to check out on hearsay evidence. There's one by Shrikant Pamela Jane, The Challenge of Hearsay Evidence. And it was published as a note in the South African Law Journal. And then there is Mampo Lokeng Munyakane, Towards a Clearer Constitutional Meaning of the Best Interest of Justice test, in section 31C of the South African Law of Evidence Amendment Act 45 of 1988. This one was published in the International Journal of Law, volume 1. There's another interesting article written by Sherika Maharaj on dying declarations. She says, should the dead have a say in a matter? Another interesting one, which I believe you should check out so that at least you can broaden your understanding of these issues, because there are a lot of interesting issues regarding hearsay evidence. Right. You remember that our section 210 of the Criminal Procedure Act remains our standard regarding the admissibility of evidence. So check that one out so that you are reminded that only relevant evidence is admissible. Now, with respect to hearsay evidence, you'll find that prior to the adoption of the Law of Evidence Amendment Act 45 of 1988, South African law on hearsay was governed by the principles of English law. So the adoption or the enactment of the Law of Evidence Amendment Act 45 of 1988 brought a definition of hearsay, and then at that, new exceptions were added to the basic rule that hearsay is inadmissible. So you find that the law on hearsay evidence in South Africa is guided by the following: the Constitution of the Republic of South Africa 1996, the common law to some extent, then this Law of Evidence Amendment Act 45 of 1988, particularly section 3, and then your Criminal Procedure Act 51 of 1977. You can check out your section 212, And then is the Civil Proceedings Act 25 of 1965. Section 34 is very pivotal to our understanding of the hearsay rule. So you must not be too lazy. Go check them out. They'll actually enhance your understanding. So the definition of hearsay, you find that the common law defined hearsay as oral or written statements tendered in order to prove the truth of the matters stated and made by a person who was not a party to the case and not called as a witness. In this case of S versus Horshausen, 1984, forgive my pronunciation, this is how hearsay was defined in common law. So that case actually expounded on the common law definition of hearsay. Then Section 3 of the Law of Evidence Amendment Act 45 of 1988 gives us a definition of what hearsay evidence is, and it reads as follows. It says, for the purpose of this section, that is Section 3(4), hearsay evidence means evidence, whether oral or in writing, the property value of which depends upon the credibility of any person other than the person giving the evidence, or the person giving such evidence. So in other words, there is a person giving evidence, but the property value of that evidence does not depend on the one who's saying it, but it depends on the one who told it to her or to him. So the witness giving the testimony is not in a position to vouch for its reliability, because it was passed on to him or to her as second-hand information, and then now she wants to boldly, posture as somebody who he knows what happened, but meanwhile it was only somebody else who shared that information with them. And so we are saying it may take the form of oral evidence or written evidence. If it takes the form of written evidence, then the rules regarding documentary evidence come into play. I think as we depart, it is very significant to take note that it is the fact that the person giving the evidence is not exactly the one who witnessed whatever incidents may have transpired. So its property value depends upon the credibility of any person. So in other words, it is not the credibility of the one standing before the court that matters, but it's the credibility of the one who told her or who told him. Take note, that's the most defining element there, the most critical element of hearsay evidence. And that is what weakens it. Because as long as the person giving the testimony cannot stand out there and say, yes, I saw it and I know this is true, then honestly, its property value is somehow severely curtailed and diminished. Look at a few examples of hearsay evidence. X is charged with theft of a computer belonging to Mr. Y. Although Mr. Y did not see Mr. X steal the computer, Y testifies that his friend Z had spotted X carrying a similar computer and walking along the street adjacent to Y's house. So the truth here is that Mr. Y did not see, did not witness what he is talking about, and is now bringing in the name of Mr. Z, who is said to have seen, witnessed, the facts being presented before the court. So in this case, it goes without saying that the testimony being given by Y is subject to the credibility of Mr. Z, who regrettably is not available to testify. So hearsay evidence is an example of evidence that may be logically connected to the issues before the court. But yet, even if it is logically relevant, it still remains inadmissible. Well, we have spoken about its probative value and the collateral issues that it raises to investigate the credibility of Z, who's not even before the court. So there's a lot that comes around. So this is perfectly in keeping with the reality that while all irrelevant evidence is inadmissible, there is some relevant evidence which nevertheless remains inadmissible. So it is relevant, for instance, that Mr. Z saw Mr. X carrying a computer. But because of the problems that arise from the admission of such evidence, you find it has got to be excluded. So though the evidence is relevant to the facts in issue, it is excluded on the grounds that it depends on its property value depends on somebody else who is not a party to the proceedings, who's not even a witness before the court. So hearsay evidence is inadmissible for several reasons, but one of the most important ones is that it is unreliable, since the person giving the testimony is not a first-hand witness of what transpired. So its credibility depends on a number of factors, including the credibility of the original witness and of the person narrating the hearsay evidence. It is also subject to the accuracy of the transmission of the information before the person who witnessed the whatever transpired and the person giving the testimony. So that greatly compromises and diminishes the value of hearsay evidence. You will notice that the admissibility of hearsay evidence occurs in terms of Section 3 of the Law of Evidence Amendment Act 45 of 1988. We will look at that a little further down. Suffice to say that hearsay evidence is inadmissible as a general rule. It is only admissible subject to exceptions. So we have common law exceptions and we have statutory exceptions. The statutory exceptions are the ones that are discussed that are revealed in this, or rather enshrined in Section 3C of the 31C of the Law of Evidence Amendment Act of 1988. So we will look at the common law exceptions, which somehow have fallen into disuse, and they've actually been in a way overshadowed by the statutory exceptions. But let's go ahead and look at some of these. So our common law exceptions, we have these exceptions applied in terms of the following. We have dying declarations. What do we mean by a dying declaration? A person maybe who is sick and is contemplating death, is actually facing the claws of death, and then begins to say certain things that maybe believes before he can go and meet his maker, his creator. He must not have any lies in his heart or in her heart. So there are so many dying declarations that people make. Others make oral wills whereby they start giving orders and instructions regarding the disbursement of their estates and so on. So some of these dying declarations may have actually been perceived to be valuable in some instances. Well, they used to be valuable. Maybe things are continuing to change, but what we may underscore at the present moment is that they have been considered. The declarations of people who are dying have actually been considered as maybe the best evidence available in some instances. So that's one exception. The other exception being spontaneous statements, when people just volunteer information. Sometimes volunteering the kind of information that is adverse to their own interests, as you will see there in item number 3, where the statement one makes is against their pecuniary or property interest. The idea is that people don't always speak to disadvantage themselves. They mostly say statements to to give themselves advantages. So a person who maybe spoke against his own interest or her own interest, if there is any report that such a person had made statements adverse to their own estate, then such statements may be admissible. And there are issues of instant responses when somebody is asked a question and without thinking, they just give what you call this, an answer. So those are some of the exceptions, common law exceptions to the rule that hearsay evidence is not admissible. So some of these statements would be admitted. It is important at this point to underscore the fact that this is not a closed list. There is no closed list of common law exceptions that could be applied. And you notice that until the repeal of section 223 of the Criminal Procedure Act 51 of 1977, you find that these common law exceptions were very, very, they were very pivotal. They prevailed a lot. Courts considered them, admitted them, but section 9 of Act 45 of 1988 then repealed section 223 of Act 51 of 1977, meaning that these common law exceptions have actually been replaced by what the Amendment Act calls the interest of justice. Thinking about these exceptions, you find that the common law exceptions as stated in section 3.1 read as follows. It says, subject to the provisions of any other law, hearsay evidence will not be admitted as evidence at criminal or civil proceedings. Each party against whom the evidence is to be adduced. So rather, it says as a general rule, only subject to these provisions or any other law, hearsay evidence shall not be admitted at civil and criminal proceedings, unless, so the unless here is the one that gives the exceptions. So unless each party against whom the evidence is to be accused agrees to the admission thereof. So in other words, both parties must be informed about the existence of hearsay, and then they must both agree that it must be admitted. So there are 7 items here. The other is the person upon whose credibility the property value of such evidence depends himself testifies at such proceedings. So, for instance, you may find that the person who may be informed, the current witness, is going to testify at a later moment in the proceedings, but just so that to allow the parties to lead their evidence without having to call the witnesses later on, they may deal with the witness who is currently before them, and then they may even lead evidence about issues that are going to be either confirmed, corroborated, or disputed by later witnesses. So just to allow and facilitate that smooth flow of the proceedings, you find that a witness who's going to be called later, they may come in and like I've said, either confirm or indicate that the testimony of the earlier witness is not true. So it says the person upon whose credibility the property value of such evidence depends is going to testify in the proceedings. So if he's going to testify, then hearsay may only be temporarily entertained, assuming that it is going to be confirmed by the later witness. And the court, having regard to the nature of the proceedings, so the court then looks at the nature of the proceedings, the nature of the evidence being led, the purpose for which the evidence is being tendered, the property value of the evidence, and the reason why the evidence is not given by the person whose credibility, or rather upon whose credibility the property value of the evidence depends. So the court will also consider any prejudice to the party which the admission of the evidence may entail, and any other factor which should, in the opinion of the court, be taken into account regarding the admission of such evidence. So these are, the statutory exceptions. Now, these exceptions have been dealt with in several court cases since the enactment of the law in 1988. Cases such as the S versus Ndlovu of 2000 and many others. And the question has been whether all these exceptions must be applied in a cumulative effect, or the existence of some and or not others will be sufficient. But what has, of course, been paramount is the fact that you see, the admission of hearsay continues to be deliberated on and is subject to these matters. As you remember, I shared a reading list with you in the foregoing. If you follow that reading list, it may shed light on some of the controversies and the sticking points around these issues, particularly the admission, of course, of this hearsay evidence. So basically, maybe as a way of summary, the reasons for the inadmissibility of hearsay are as follows. One, it has low probative value. That was revealed in the S versus Ndlovu 2002 case. The court stated that probative value means value for purposes of proof. And this means not only what will the hearsay evidence prove if admitted, but will it prove it reliably You see the reliability element here. The fact that the probative value of the evidence depends on somebody else who's not before the court diminishes its probative, its value really before the court. And so if the probative value is negligible, then it is inadmissible. And there is the credibility of a non-witness. Remember, the person who purports to be the witness and is talking and maybe leading this evidence, presenting the evidence, is not a witness. He's a witness, yes, but not a witness. And again, the person who actually may have observed the developments or the act being deliberated on, the one upon which the charge is based, is not part of the court, is not a witness. So their credibility is not tested through cross-examination. The veracity of their claims are not, tested, and we don't even know whether the one claiming to have received the information actually received it and is communicating it the way it was received. Because you see, there's always error and distortion during the transmission from one person to another. So as a result, it may be very problematic to rely on that hearsay evidence. And then, so to what extent can a witness be believed? Credibility depends on factors such as the truthfulness of an individual, her trustworthiness, her powers of observation, and her memory. And all those are not tested in the court. It is through cross-examination that credibility may be established. Therefore, a testimony given on behalf of an absentee witness is not subject to such verification processes. And the witness giving hearsay evidence cannot vouch for his truthfulness. I think we've underscored this point. And the maker of the statement does not testify and is not subject to cross-examination of the content thereof, and it depends on the credibility of another person other than the witness. So, and we are saying it doesn't matter if the other person testifies later on or not. The testimony currently before the court does not really add much value. Its probative value is very minimal and negligible most of the time. You may want to check out the cases such as the Hlongwane versus Rector, St. Francis College 1989, or the McDonald's Corporation versus Joburg's Drive-In, or even the State versus Ndlovu 2002. Those cases would shed light on some of these issues that we are discussing here. So what has been the impact of the Constitution of 1996, the South African Constitution? Well, the adoption of the Law of Evidence Act 45 of 1988 saw the repeal of the common law exceptions, as we have already discussed above, and then the inclusion of the interest of justice as the new standard. The exact meaning and scope of the interest of justice standard has not been conclusively defined, and considering that the Law of Evidence Amendment Act 45 of 1988 was adopted 8 years before the adoption of the Constitution of 1996, it goes without saying that the principles enshrined in Section 35 of the Constitution were not factored in, they were not considered in the drawing of the 1988 Act. So since the adoption of the Constitution, courts have endeavored to apply Section 35 as a way to protect the interests of justice goal. So in S versus Ndlovu 2000, the court considered the meaning of the interest of justice in the context of the current constitutional dispensation. And you find that issues to do with the fact that hearsay evidence depends on somebody else, the other party against whom the evidence is being adversely held, it actually is prejudiced by the fact that he or she cannot test the veracity of the evidence, maybe by way of cross-examining, the actual witness, the absentee witness. So in this case, you find that the right of the accused to test the veracity of the evidence through cross-examination is denied in all instances where hearsay evidence is admitted, and certainly that is prejudicial to the interest of justice of the accused. But in some exceptional cases, the court may admit such evidence if the interests of justice demand it. What about the cases of minors testifying maybe through an intermediary? Maybe because of the need to protect minor children who may be victims of abuse, all forms of abuse, including maybe sexual abuse and so on. You find that they may have to, testify through intermediaries who could be their parents, their guardians, the social worker, or their teachers, or whoever may be appointed in law to represent the minor. So to protect the child, the child may be excluded from appearing before the courts, but then the intermediary now has got to speak on behalf of the minor. Obviously, that's a case of hearsay, because remember, the intermediary is not the victim in the case. Therefore, whatever statements are being made in court, they are dependent, their veracity, rather their probative value, is dependent on the child, who unfortunately, for policy reasons and to protect the child, is not permitted to appear before the court. So you find that it is in a way prejudicial to the accused, because then they cannot test the truth, veracity of the claims being made. They cannot subject the actual witness to a rigorous cross-examination and interrogation process. But as we have said, those would be exceptional cases where a court would admit such evidence in the interest of justice. Considering that children must be protected, the courts will not hesitate to consider and to admit hearsay evidence, particularly to do with the protection of the children. So maybe as a last item, it is very important for us to distinguish hearsay from confusingly similar concepts. Which are those confusingly similar concepts? We've got your previously consistent statements, you got your admissions and your confessions, and they sometimes do seem like they overlap with hearsay evidence. Take note that it is always a case of hearsay evidence if the person making the testimony is not talking about his or her own personal experiences. So if a witness testifies about what another person told her, or testifies about what was told to her, then it is hearsay. However, if the witness testifies about a statement previously made or given by another, then it is a case of a previous consistent statement. I think if you check the video on previous consistent statements, you will be able to fully grasp the scope and the meaning of previous consistent statements. If a witness tells the court that another person confessed or admitted some facts, then one is dealing with a confession or an admission. What are we saying here? A police officer may interrogate a suspect, and then through that interrogation process, the suspect may admit or confess to having done one or two things, and then the police officer comes before the court as the witness and testifies about what was said by the accused. That one is not hearsay, but we are dealing here with a confession or an admission in the presence of a peace officer. In all instances involving hearsay evidence, only the rules regarding the admissibility of hearsay will be admitted. So it's very important to always remember admissibility, and we spoke about the common law exceptions as well as the statutory exceptions. Just revisit your Section 3 Act 45 of 1988 for clarity on these matters. Once more, thank you very much for being part of this presentation. I hope it has enriched you. This video looked at hearsay evidence. It was revealed that hearsay is, as a general rule, inadmissible. So hearsay evidence is generally inadmissible. It is only admissible subject to common law and statutory exceptions. So there are exceptions which justify the admission of hearsay evidence. Otherwise, in the absence of those exceptions, hearsay is not admissible. Now, check out the other videos on opinion evidence, character evidence, similar fact evidence, previous consistent statements, and admissions and confessions. We have other videos on privilege, the treatment of evidence obtained in violation of the Constitution, among others. Of course, taking note that we have more other videos to do with the, assessment of evidence. Even before we get to assessment of evidence, we have got other types of evidence, and then we have got the process of the presentation of evidence. How the proceedings are conducted, and then how the veracity of the evidence is tested, the examination in chief, cross-examination, and re-examination. We have videos on all those things, so just stay connected in order to access all of them. Otherwise, in the meantime, click the subscribe button, like the videos, share the videos, and follow us on all our other channels and all our other platforms. May God bless you. Have a great day.